Israel has become known as the startup nation. In fact, during to the book of that name you see on the left, that's one of the covers of the original version. And on the right, there is a version in Chinese, I believe, and I understand that it has been translated into a number of different languages simply because it is such a fascinating story. So the question is, and this is the question that's asked in other books as well, what's the secret? Well, the truth is, sometimes there's no specific secret. It's just getting the job done, just getting on with it. It helps to have support from government and from business. It helps that academia is supportive. And it also helps, obviously, to have investors interested from overseas. There are various seminars that one could go to which will pay how many companies, how much money, how many deals, with a lot of interesting statistics. This seminar is not that. We're trying to be a little bit more practical, trying to provide useful thoughts to generate questions that one needs to ask when getting involved in a commercial sense with an Israeli startup. So, as you see in front of you, we have 4 presentations. The first one is not, even though we are an IP firm, or JMB is an IP firm, it is not going to mention, I think, IP at all. It's corporate structure considerations. I'll introduce Didi in a minute. The next one will be IP related, but more a question of the IP issues or pitfalls, things that one has to be careful of when looking to buy into a company and the IP that it owns. This is not a seminar on how to procure IP. Again, it's more a question of some of the pitfalls around it. We will then be moving to Dr. Naomi. She's the VP of IP at BGN. We have to thank her especially because she's not feeling well today and we weren't sure whether she was going to be able to present. So we very much. And this is all about TTOs, and well, you'll hear exactly what she has to say about this very, very important sector in the Israeli, not just in the Israeli startup scene, but in the Israeli economy overall. And finally, we get to the IAA, the Israel Innovation Authority. They give money, they don't take shares. So what's in it for them? And what strings are attached? Are strings attached? These are things one needs to know when getting involved with companies which have those sorts of funds. Let me introduce Didi, our advocate Yedidya Melchior. He's a founding partner in Lapidot, Melchior and Abramovich. He serves Israeli and foreign clients in corporate and commercial transactions, including high-tech financing, IP licensing, international transactions. And they also represent companies in litigation relating to those areas of practice. I've introduced Didi. I've mentioned his subject. Now I will stop sharing and allow him to, so that we can proceed.
Thank you, Jeremy. There was a tale involving the hoopoe, which is Israel's elected national bird. There was an election 12 years ago, and you can see a picture of the hoopoe here on the on your screen.
Yes.
The tale relates the hoopoe and the biblical King Solomon, who could, according to the legend, speak animal languages. One day, the king summoned the hoopoe, but it was nowhere to be found. And when it was finally brought in front of the king, its excuse was that it traveled to faraway lands, not controlled by the great king, sort of a scouting expedition. And it came upon a country with soil richer than gold and with silver lying out in the streets as garbage. This was, according to the legend, the kingdom of Sheba, and thus began the relationship between King Solomon and the Queen of Sheba and prosperous international trade. So maybe the hoopoe is a good introduction to investing in Israel. In the next 15 minutes, I will try and provide you with some insights about legal aspects of investing in Israel. I will be using birds as a metaphor, but it's not going to be about biology, more about business and law. So the first thing when you invest in a foreign country is understanding the local culture and the local spirit. Typically, when you invest in an early stage company, you expect them to be patient, waiting for you to come and feed the young fledgling, very dependent on its parents to bring in along all the resources and all the knowledge. Israeli startups are in that sense a bit different than startups in other places because they are like fledglings with chutzpah. They don't understand sometimes that they are much smaller, that they are dependent. They don't feel any problem with shouting back or thinking that they know exactly how things should be done. And it's a cultural difference that comes with a lot of advantages. There's a lot of creativity, a lot of new and unique expressions, and a lot of technology that comes out of that spirit. When you structure a deal, that is something you need to take into account. You need to balance between allowing that freedom, the free spirit to prosper, and of course, structuring it on the business side. In general, Israeli investments allow both for flexibility and for versatility. I'll jump in a bit deeper regarding each of these attributes. First, about the flexibility, I'm talking mostly about flexibility and structure. The typical startup investment is an equity transaction. That is, the investor invests money in a company in return for shares in the company. We'll discuss a bit later on what type of shares you can have. And that's a standard equity transaction. There is, of course, a discussion of valuation. As part of the flexible structure, you can have, for example, adjustment mechanism that are based on how things, how many milestones are reached. Maybe it will increase the investment amount when you reach milestones. Maybe the valuation would be higher or lower depending on how you reach the milestones. But that's a typical equity transaction would have a fixed price for the shares. You know that if you invested $1 million in a $2 million pre-money valuation, you would have a third of the company. Second structure is a classic debt structure. That is, the investor is not becoming part of the company, but rather providing a loan to the company. It's financing it similar to a bank debt. Banks typically, except for certain circumstances, don't finance Israeli startups. But there could be private investors or various investment funds that do specifically provide debt structures. Advantage from the investor's perspective is, of course, that he is a creditor and not an owner, and that puts him specifically if there is an asset but there is a high risk on the creditor line, is a more secure place to stand. And there is, of course, the ability to have some form of security in a startup. It would typically be, Jeremy said, I won't mention IP, but here it comes. There could be, you could use the IP as a collateral, but again, that depends on how valuable that IP would be to a third party that is not this specific target company. Then, of course, we get into a convertible debt, trying to enjoy both benefits. It starts off as a debt, but there are terms in which this term is, this debt is then converted into equity. For example, if the company raises a certain next financing significant round, then that debt would be converted into that round, typically at a discount because it was provided earlier with a higher risk. There could be conversion that is based on an exit transaction. It could be conversion that is based on reaching milestones where the risk is reduced and so on. Again, these are flexible structures. We have hybrid structures that also, like the convertible debt, provide both of them, but you stay with both of them. So for example, you could have a typical venture lending transaction in which the investor provides a loan, but in addition to the interest he's getting on the debt, he's getting some sort of a kicker or upside or a warrant to participate in a future investment. So while the basic amount is provided as a loan, he does participate in the success of the company further on. And there are some structures that look outside the investment. Sometimes there are added values, some synergies. For example, an investor in a specific technology or product might also have a business in his local country. He might be a good fit for a distributor in the region where he otherwise operates. So he brings some other added value in addition to the equity or debt that he provides. He also gets a benefit in the form of distribution rights or other business rights that he gets. When we talk about the versatile arrangements, even if we dig into the specific aspects, so you could have, for example, as a basic concept, we have the freedom of contract with very few limitations. The parties are free to agree on the terms that they want. So again, with these very minimal within those very fluid boundaries, the parties can agree on the form that the investment is going to take. For example, if we look at a typical equity investment in most startups, not all, but most, the investor would get preferred shares. And typically, these preferences would develop over the lifetime of the startup. So for example, the investors in the first round would get preferred A, investors in the next round will get preferred B shares, and so on. We actually had one of the companies that we're representing the lead investor in, their IPO is due in 2 weeks. They were up to the preferred H before they now converted everything to ordinary shares as part of the IPO process. So the preferences could take different shapes. Again, there's no one rule, but for example, the key rule would be liquidation and dividend preferences. That it means that the investors get their money back first and then further participate in allocation among the shareholders. Again, these are all flexible structures in the sense that you could have that return be 1x, meaning 1 time the investment, 2 times the investment, a certain time plus interest, or they could be, for example, on a very successful exit transaction, maybe even be not applicable at all. An investor should insist, specifically if he's providing a big portion of the investment, on having board appointment rights. That is goes back to the free spirit, and at least you want to have some form of control over what's going on, and that connects directly to the voting rights. But again, of course, every share has a voting right. That is totally the standard. But from an investor's perspective, the most dangerous area to be in is to be a minority shareholder, which is typically the situation in the first couple of rounds where the founders still own the majority of the company. But that also means they control whatever you do with the investor money. So typically you would have some form of veto rights to control what the company does, avoid, for example, related party transactions, founders increasing their salary, or changing the auditor, which is one of the things that's important to the investor, so he knows that the company is properly audited, and so on. Again, the various VCs have 15 to 20 items on the list of what they want to veto, but of course, this is also always a balance of what you reach in the negotiation. And then, of course, you have other rights, the right to participate, the right to protect the value of your investment, and so on. We won't dive into each of those. Again, these are not unique to Israeli structures, but they come with a flavor or with a twist that needs to be taken into account. As I mentioned before, with the additional benefits, there could be other additional investor-related transactions. For example, we've had a case where the investor had good connections abroad with certain medical facilities, so they could assist in the clinical trials that the company had to do, and suddenly provided a large market, much larger than the Israeli market, for providing or conducting those medical trials. So sometimes, again, specifically when it's what we sometimes refer to as smart money, there is the ability to enter into another related transaction as part of the investment transaction and enjoy the benefits of the foreign investor can bring to the table. Now, when we talk about international considerations, and going back to the bird metaphor, you can see here in the map, Israel is key place for bird migrations, both during autumn and spring. Some birds choose to stay in Israel over the winter. We hope that the investors choose to stay here longer. There are about 300 species that migrate through Israel in addition to the residential species. Just comes to show, again, going back from the metaphor to the business investments, that there are a lot of types and a lot of ways we can address these investments. Now, in addition to the general considerations, all the issues I mentioned before apply equally to both Israeli and non-Israeli investors. International considerations have additional aspects taken into account. The first one is taxation. Of course, assuming you make a profit from your investment, you would prefer paying a lower tax. As a general rule, there is an exemption for capital gains investments in Israel from foreign investors. That's a very important aspect in Israel, sort of attracting additional foreign investors into the Israeli high-tech scene. But that means you need to take into account that it's not always a capital gains transaction. For example, equity is capital gains, but if you provide a loan, as we discussed before, then suddenly interest could be taxed in Israel, again, depending on the next issue, which is the originating country and what tax treaty it has with Israel. Sometimes if you're investing from a country which does not have favorable terms, it would be wise to set up a vehicle in between your originating country and Israel to enjoy the tax benefits. Again, it's not an issue on the capital gains, but it's an issue on other types of gains. For example, if this is a profitable company, you expect that it will allocate dividends, then we're not in the capital gains exemption, and we need to look at dividend taxes. If it's a loan, then we need to look at the interest taxes. If it's an exit transaction where the company is not sold, which is a capital gain, but rather the assets are sold, then again, you're looking at a taxable transaction, which is something you need to take into account when planning the investment. Of course, it's harder to change after fact than before the investment. Another consideration is the corporate structure. There's a difference between a private investor. For example, Israelis typically enjoy lower tax if they invest privately and not through an entity, at least in capital gains scenarios. Foreign investors sometimes pool together, and then there's the issue of through what vehicle do they invest? Do they invest as a corporation? Do they invest as a partnership? Typically, venture capital funds are partnership structure because that is a see-through from a tax perspective, meaning there's no tax on the individual level, and the tax goes back to each of the partners in the partnership. Again, going back to another issue that we discussed before, international player can provide local added value. It could be, again, distribution rights, clinical trials. It could be connections with key customers or possibly key acquirers. It could be, for example, a company that targets a specific region because the solution that it provides has markets that are sometimes very specific, either because of weather conditions. For example, probably a Scandinavian investor would not be able to provide as much a benefit on distributing air conditioning technology, but someone from Saudi Arabia probably has more use of that. So you would have some adjustment to where the investor can bring added value. This can, of course, play into the valuation. If you come to the company saying, I'm not just money, I have some additional added value, then that's something to take into account. And this was covered somewhat in the previous session of discussing government benefits. Then you take into account that government benefits might impact the ability to export technology. So depending on what it is that you expect to do, that's something to take into account. Compliance. Again, this is an issue mainly for foreign investors. So the first thing is stealth mode. Like you can see the owl hiding in the tree here is trying to be stealth mode. Sometimes investors do not want their involvement in a company to be known. Sometimes the company itself is in a stealth mode where it doesn't publish what it does. So we need to differentiate between the two issues. The company can continue being in stealth mode. Having the investor be in stealth mode is a bit more complicated. First of all, we need to comply with know your client, anti-money laundering considerations. That means that these requirements are both by the bank, where the money is supposed to arrive at the end of the day, meaning the bank will need to do its compliance issues. Typically, the lawyer who will represent you in a financial transaction will also need to conduct a know your client process. This is, of course, passed on both to the anti-money laundering authorities, sometimes to the tax authority, again, depending on the type of the transaction. And finally, one thing that is common in some countries and totally not understood in other countries is the public registration. So if you're providing a loan and you get a pledge or different kind of security, then it's very common in most countries that there is a public registry where these things can be reviewed. But the share registration is not something, for example, that's common in the US. You would not find a public registry of the shareholders in a private company. In Israel, that is the case. That means that when the company issues shares to the investor, it has to report to the register of companies within 2 weeks of the issuance. So these cannot be kept secret. Now, of course, you can register the shares in the name of the trustee, but if the stealth mode is something that is important in a particular transaction, then this also is something that needs to be addressed. By the way, it's not just the shares that are public information, the ownership, but also the articles of association, which is the governing document. So you would see, for example, the terms of the liquidation preference, other voting rights, and so on. They are not secret. That is something you need to take into account. If you don't want your name associated with it, you need to have some sort of trust arrangement in between. And of course, you need that trust arrangement not to work against those tax benefits. This all comes down to the conclusion that you need a tailor-made solution. Just like the rough bird, which you can see here in the picture, which is, by the way, also one of those birds that migrates through Israel. Tailor-made solutions means that no one solution fits all because of the different taxation, because of the difference in technology, because of the difference in added value and all these other aspects. You will need a tailor-made solution. That does not mean that investment transactions, we start from page one and start indenting on the first page and drafting everything out as a new document. There are conventions, there are templates used, but the key here is adjusting them to the specific scenario. The other, the next issue that relates to the tailor-made solutions has to do with the due diligence. Find out the specifics, both about the market, about the founders. Many times, not less important than what the technology is of course the identity of the founders. Look well at their previous conduct, also in this company, the contracts that they've made, the IP that they've registered or decided to keep as a trade secret, and evaluate that. Adjust the circumstances. Again, things come up during due diligence. You'd be surprised at how many unique solutions and sometimes very problematic solutions founders have adopted as sort of a shortcut that come with a problem on the long run. And of course, address the specific pitfalls, things that you find in due diligence. But doesn't mean you need to give up on the investment. If it's a good investment, if you believe in the technology and the product, there is usually a solution that can be found, how to correct past mistakes, how to secure that things are under control moving forward. And that's about it. So if you're ready to dip your feet in the water, then you're more than welcome to come and invest in Israel.
Thank you very much, Didi. As I mentioned before, if anyone has questions, please submit them through chat. I see there's something on chat already, so I'll take a look at, and we will discuss the questions later on. It's true. Did I say you wouldn't mention IP at all, or maybe mention it once? Well, I'm grateful that you mentioned it once, but before I get to that, I mentioned old friends and new friends before. You talked about, sort of the markets. And for example, hot countries may require air conditioning more than others. I'm paraphrasing what you said, which actually leads to me to one of our new friends from the United Arab Emirates. We spoke with you, Zahra, a couple of weeks ago. We're glad you could join us today. And while we've been talking, I would say I've realized the geographical bounds of this small gathering here extend all the way from Argentina, hi Ariel, through the west coast in the United States. And I think that the eastern border is still Tokyo. But anyway, it's good to see everyone. So the question of IP. Okay, of course, there are a lot of things that you need to know with regard to the entire business structure, but without giving too much away, if you're not actually sure how ownership works, then you might become unstuck. I'm not going to say anything much more about the next session, except to introduce Mike, Dr. Mike Hammer, and Avram Hermon. They're both partners at JMB. Mike is a US patent attorney. He heads our US practice section, and he is a biotech specialist. Avram is a US patent agent and an Israel patent attorney. He has extensive experience in pharma. He likes, let me rephrase that. He has become very well versed in advising clients in connection with medical cannabis. And I will now let Avram please present, and Mike, the two of you.
All right, thanks, Jeremy. So I'm going to start off and then turn it over to Avram. Hello, everyone. Thank you very much all for joining us. Avram and I are going to be speaking today about some of the potential IP issues that you might be thinking about when you're thinking about investing in Israeli startups, or your clients may be thinking about investing in an Israeli startup. And when I was thinking about this topic, an old kind of cliched, maybe American expression came to mind, which was that if you hear the sound of hoofs, you should first look for horses before you look for zebras. And that's a funny way of maybe saying, think about the standard things first before you think about anything too exotic. And I would say that most IP issues that one might consider when thinking about investing in an Israeli startup are the same types of issues which you would be thinking about anywhere, no matter where you are, maybe no matter where you're investing. These are the standard due diligence issues of what type of IP does a company have, and is there anything pending, and what's the connection between that IP and their product? Are there FTO issues? Have they been solved? What's the potential patent term for any given piece of IP? And also, the standard, which is who owns the IP. In our practice, somebody asks me the first question, which is, can I speak to somebody? And I go straight to the USPTO register and look at the assignment record. Who owns the IP? Are there things which may not appear on the record, licenses or other kinds of agreements, those types of things? Those are pretty standard. It doesn't really matter whether you're in Israel or whether you're in the States or anywhere else around the world. But there are a few things which, if you're thinking about IP issues and an Israeli company, that you do need to be considering. One of them, Hillel is going to be speaking about in a little bit more detail later, which is, has the company received any money from the Innovation Authority? And what connections that might have to a specific piece of IP or a specific product? And is there any kind of a string attached? Is there not a string attached? And Hillel will talk about that further. The other issue, which does have a specific Israeli flavor, is do the inventors themselves have any rights in the IP? It's not like in the US where the rights in the invention begin with the inventor. There's a slightly different spin on it here, and that's exactly what Avram is going to continue with now.
Okay, thanks, Mike, and thanks everyone for joining. I'm happy to be here in this international convention from the comforts of my own office. So the question that we will ask is, what rights do Israeli inventors have? And the law is actually pretty clear. The Israeli patent law of 1967 is pretty clear about Israeli inventors who are working as part of a company, and has this term called service inventions, and defines this service invention as any invention that was done during the employment and as a result of the employment of an employee that is owned by the company, basically automatically. And if there is to be a dispute about that, then the company will receive rights to that invention. If there's a working relationship between the company and the employee, and it can be shown that the invention was made during the employment and as a result of the employment. But there is an interesting twist here in that Section 134 of the Israeli patent law talks about compensation. And it says specifically that if there is no agreement regarding remuneration or compensation for the invention, then the matter is decided by the Compensation and Royalties Committee. So what is this committee? The committee is formed of usually the Commissioner of Patents and 2 other participants who are lawyers or judges or retired judges, and they decide what sort of compensation. So what we understand from this is that a contract can take into account consideration or compensation for the invention. But if there is no mention in the contract is silent about compensation, the inventor has some sort of right to compensation and should be able to receive that compensation. And as a resort, he can turn to this committee of compensation and royalties. I'm going to talk a little bit about a case that went to the Supreme Court, and it's close to my heart because I was working at the company and I actually know the people involved in the product that was involved. There's a small pharmaceutical company called Teva Pharmaceuticals. It's the biggest pharmaceutical company in the Middle East, one of the biggest generic companies in the world. And in addition to the generic side, there's also an innovative side where the company developed new products. And we're going to talk about one of those new products. And I was actually involved in the patent side of this development, filing applications and prosecuting applications relating to this product. And we're going to talk about the product called Azilect, which is pictured here on this slide for those chemistry buffs here. And it's a drug that was developed for treating Parkinson's disease. And it started in a collaboration between Teva and the Technion Institute in Haifa. And it was an invention of Professor Musa Yudin of the Technion. And this collaboration started in 1987, and a priority application was filed in 1990 on the compound itself. And just to give you an idea about how long it takes to develop drugs, between the filing of the patent application and the actual FDA approval was around 16 years. So it is indeed a significant effort. And this is one of Teva's first and rather successful drug that was innovative. And one person involved in the development was a woman named Dr. Ruthie Levy. And she retired in around the year 2013 and was offered a compensation package. And with this package, she got a document from Teva which said, you are expected to waive your rights to royalties for your inventions. And she was an inventor on a number of patents, including patents that had prosecuted. And at this time, in 2013, she said, oh, this is strange because it appears that I deserve something and they want me to sign a waiver. And she went and checked it out. And eventually in 2015, she files with the committee, this committee for compensation and royalties. What happened next was as follows. The committee sat and addressed what her rights are in this for royalties. We know she wasn't disputing the fact that the ownership of the invention is Teva's. But the question is, what sort of right does she have? Was she compensated all along throughout her employment? Was she given some sort of royalty? Just to give you an idea, she left in Teva in 2013. The sales worldwide of this drug Azilect that she was involved in inventing or developing were $493 million that year. So it's quite a bit of benefit that Teva saw from this drug. So the Compensation Royalties Committee said as follows: there is a right to approach the committee, and essentially the contract, the employment agreement between Dr. Levy and Teva did not mention compensation. So at one point there was a right to discuss this compensation with Teva and come to an agreement with them. And if that didn't work, then she could have approached the committee. And this could have happened, the committee said, at one of three points in time: at either the time of the invention, the time of the filing, and the time of commercialization, which we say is 2006. Okay, it didn't happen at any of those times. It happened in 2013. I'm sorry, it happened in 2015. Happened a bit later, after she left Teva. And what's interesting about this decision was the Royalties Committee didn't really decide which exact time was the time that was the final cutoff date. It said the trigger is essentially one of these times, and it didn't decide which one. But even if the latest time were taken into account, the time of commercialization in 2006, that means she should have approached the committee at 2006. And she didn't until 2015, and the statute of limitations in Israel prevented her from then further approaching the Compensation and Royalties Committee. So because of that, 7 years at least have passed since any of these dates. The time of invention was 1990. So we're talking about many years after, and the time of filing was also much earlier. Even if you look at the time of commercialization, the statute of limitation here applies. So she essentially lost that right to claim compensation from this committee. And this petition was further petitioned to the Supreme Court, in which the Supreme Court upheld the decision of the Compensation and Royalties Committee, essentially saying, if the contract is silent about compensation, then there is a right, but the right is waived if it isn't used in a certain time, and that the statute of limitation applies. So let's talk about practical take-home ideas, take-home messages regarding this issue. So if you have an inventor and you're checking out a project and you want a due diligence process done, what do you do? So it's important to understand that if you don't want to have any surprises, the inventors have to, they can waive their rights to compensation. And I think it's pretty standard in agreements that if there is something that says in an employment agreement between a company and an employee that the rights belong to the company, A, and B, any compensation for or royalties for any inventions will be included as part of the salary, that's already sufficient. And then the company can essentially tick off that box and say, we acknowledge that there is a possibility of compensation, and we're paying for it. By paying this salary, we are essentially paying for it. It doesn't have any further requirements. So it's important to understand that and keep that in mind. It's a standard agreement that only talks about rights in an invention and does not talk about the possibility for royalties and compensation and payment for making that invention should be looked at with scrutiny and might be a cause for concern for potential investors.
So Avram, do you think
this is essentially the lesson?
I'm sorry, do you think the suggestion would be then that investors should be looking at employment agreements potentially of inventors on different patents and patent applications?
Certainly, if the technology is critical to the acquisition or to the investment, then they should be looking into this matter, because you're buying a company or a product, and you're making this investment based on a certain cost. you can't be certain that the cost won't increase if an inventor makes some sort of claim, especially in very early stages. You know, if they make some sort of claim and this product becomes successful, you have potential for an extra added cost of this investment or product. So it's an important thing to keep in mind. That's all I have from my end, and we'd be happy to hear questions at the end. Thank you.
Okay, thank you very much, Avram. Thank you, Mike. One of the things that was clearly central to your discussion is the fact there are people involved. And this is something that much as we would like to forget sometimes, you know, we talk about corporate ownership. There are often these, what I would call residual rights, which the corporations, when they're just getting organized, don't necessarily take into account. And it's because people don't know. A startup company takes an advisor. The startup company itself has nothing to do whatsoever with any other company, with any university. And it takes an advisor who happens to be a lecturer at one of the universities. And often they're unaware of the fact that the lecturer has already signed off certain rights to the university where he's employed. And in fact, on occasion, he himself hasn't even read the contract that he signs because it's pretty much boilerplate. And so these are things which are often not taken into account, but you know, merely to reinforce what Mike and Avram you're talking about, these are things that need to be looked into. It actually doesn't make any difference who the investor is, because you think sometimes, okay, I'm getting involved with company X, and these three folks that are running it, but actually you could be getting involved with a university, or rather with a tech transfer company. And when the IP is worth nothing, when the company is worth very little, no one really cares very much. It's relatively easy. I wouldn't say easy, but can be relatively easy to sort things out. When do these become real problems? When there's success on the horizon. All of a sudden, it's a lot of money. And I remember hearing years ago that possibly the leading of the oldest tech transfer company in the country, which is Yisum, I believe it's Yisum, they have made vast sums of money. In fact, as far as I understand, they're even the primary income earner for the university. So if there's money to be had based on rights that they have, they will not give that up very easily. Anyway, if we're talking about people and we're talking about tech transfer and academia, that sounds like we should be moving on to onto Dr. Naomi Ziv from BGN, her presentation about tech transfer. So Naomi is a patent attorney. She's got a mathematics and chemistry, and she's been at BGN for the last 8 years. In 2012, she started as Director of Intellectual Property, and since 2017, she's the VP of Intellectual Property. So without further ado, as they say, Naomi, over to you.
Thank you. I'll share my... Hi, so good morning, good afternoon, good evening to all of you. Thanks for joining. I'll give today the perspective from a TTO, the Technology Transfer Company. And how TTOs can evolve and change their focus these days, these modern days. Basically, technology transfer offices started around 1980, after in the United States, the Bayh-Dole Act was approved, which was an amendment to the US patent law. And in regards to universities, it said that universities can now own the IP stemming from government-financed research. And the aim of this amendment was the thought was that technologies can be the engine of economic growth, and the main aim was to advance collaborations between scientists, business, and industry. So take advantage of all the wonderful inventions from university and try to promote them and turn them into products and processes that are beneficial to other societies. The main goals of technology transfer companies is to protect the researcher's inventions via patents, and give companies licenses to use these technologies, and also be involved in founding startup companies. So the general processes at the Technology Transfer Office is when the researchers have new inventions, and they report them to us via a disclosure, a form called New Invention Disclosure. And because they're keen on publishing their research, in academia, one of the basic values is to share the knowledge and publish it to the community. So TTOs try to file patent applications prior to the publication. Normally, we file a provisional patent application, and then we have about a year until the PCT application to make additional evaluations, commercial evaluations, patent evaluations, and see how to proceed. Eventually, the aim is to license this invention and or found a patent startup company. So basically, TTOs are the bridge between academia and industry. And another interesting aspect of TTOs is the large areas of research. Well, certain companies are concentrating on one aspect, either pharma or clean tech or cyber. We have a large portfolio covering many various scientific disciplines. Now, over the years, it is evident there are so many TTOs and so many universities, and some TTOs are more successful than others. Some had launched, they had great contracts or agreements and developments, and they're very successful. They have, their income is high or otherwise successful. And the question these days is, how do you actually measure the success of a technology transfer company? Is it by the number of patents that it files each year, or perhaps the income from licensing or from other agreements? Maybe we should count the number of inventions, or perhaps, just a sec, my Zoom is a bit. Perhaps the number of agreements that we sign, or the number of startups that we found, or perhaps other models. Well, there are several initiatives that technology transfer offices can take, and the successful ones have taken or are taken, in order to bridge this gap from the lab to the industry. One of them is investing in the first stages, closing the gap, and I elaborated on that in my previous talk 2 weeks ago, where the TTO should invest additional research and funds, look for collaborations, even at the early stages of the invention. We have planning ahead, especially during the first year between the provisional application and the PCT application, planning additional experiments, thinking which examples and demonstrations will make our patent application strong, and with a strong patent application, it is easier to commercialize. And we also have, we're active in the various programs of the Israel Innovation Authority. Some programs help to match academic research and companies, and then they can invest and navigate the research towards practical results that can lead to further product development. And in our university, we're very active in these programs and quite successful in the past few years. Another direction is being more entrepreneurship programs. There are many researchers that really would like to do more than just research and be active and be the driving force in building their startup. So various universities like MIT, San Diego have entrepreneurship programs. And also here at Ben-Gurion University, we have an entrepreneurship center called Yazamut 360 Degrees, where this center teaches entrepreneurship and innovation skills for faculty and students. They're quite successful. During the past 2 years, they managed to establish more than 30 startups each year. And they have a program for students. And regarding the researchers, there is an accelerator for researchers called Oasis that guides and gives those researchers that would like to forward their invention and see it become a real product and build a company. So they have this help. Another thing that's extremely helpful for technology transfer offices and universities is being part of an ecosystem. It can be a science park in most cases, or other areas where there are many biotech companies. Or we have, for example, in San Diego, such an ecosystem. In Israel, we have this in Rehovot near the Weizmann Institute. And also here in Beersheba, we have an advanced technology park with many high-tech companies. And there are close collaborations between researchers and the companies. Some are startup companies, some are international companies, and there are all kinds of other programs like accelerators that work from the park and where the university is involved. And also our company, BGN, the TTO. Another important aspect is to keep contacts with the industry, ongoing contacts. This can be two sides. Either the TTO business development people can be in touch with various companies and interest them with new projects that we have. And on the other hand, also some companies can check every once in a while with the TTOs. Is there something new? Are there new projects? And something that you can take on and be involved with. If you're looking for new ideas for startups, TTOs is a very good starting point. Another issue is to be proactive instead of just sitting and waiting for inventions to come to our door. We have regular meetings with the researchers, looking for good ideas, promoting collaborations, and encouraging them to also talk with us. And lastly, it's very helpful to also have an active patent department, a modern department. We'll look not only at the number of inventions that we receive, but also take a check about their quality. We're involved in all stages of these of the inventions, of the patenting. We work with researchers, business development units, outside counsel, finance department, and consultants. And we are part of the whole process. We're also involved in educating and giving professional support to the faculty and our teams in regards to all the patent issues. It is also important to use modern analysis tools when the portfolio is big and complicated. Using the old tools from 20 years ago is a bit limiting. And the important thing is to keep innovating and updating all the processes, the working processes, the analysis processes, the working with all the other departments. So to sum it all up, technology transfer offices are both an engine and a bridge between research and academic research and industry, and could be a great starting point for looking for new ideas, startups, and developing new products. So thank you very much, and I'd like to hear your questions at the end of the sessions.
Thank you very much, Naomi. Of course, the context and the environment that you work in is by definition one of academia. It's on campus, which of course is a very vibrant sort of backdrop for a tremendous amount of very high quality development. One of our guests here today, actually, Ting from Guangzhou, is someone that she is involved with an IP firm that's on a very, very large campus in that city. Mike and I actually first visited there 4 years ago, and anyway, Ting, we're very, very pleased to have you join us. Ultimately, we've spoken about two things. We've spoken about money, spoken about people, and we're really going to finish off with money. And as I mentioned before, the Israel Innovation Authority is responsible for a tremendous amount of funding for startup companies. And it's a bit of perceived as a bit of a double-edged sword, because on the one hand, the government says, or in fact it's public money, but it's an independent authority, under certain conditions, we will give you money. And no, we don't take ownership of the company. Okay, but there's a problem. And the problem is that companies often end up either transferring their technology, their IP overseas, or transferring everything overseas. And in fact, I think that Rob from Symbiosis, if I'm not mistaken, I think you mentioned not precisely this problem, but the fact that Israeli startups are seeking to exit early on, which of course, when you're talking about a company that isn't yet quite mature enough, they might be missing out. A different type of problem which also relates to the time that a company hangs around, is actually a problem that I heard of a number of years ago. I was in New York for an Israeli company investment conference. Chemi Peres was one of the speakers there, and he referred to the problem that when companies when they have an exit, which involves them receiving a large amount of money, or at least the owners, for being absorbed into the structure of a parent company, which is normally overseas, very often in the United States. Initially, everyone is saying, we're only interested in what's good for everyone, which means that the company is going to stay in Israel. Statistically, within 2 or 3 years, the vast majority of those companies relocate. Either the company structure in Israel is taken apart and all that remains is the IP, which is owned now overseas. Maybe a few of the more talented individuals find jobs leaving Israel and going to the parent company. And very often not even that. After all, the parent company, it can say what it wants, but it probably isn't obliged to keep operations in Israel, and it certainly doesn't make sense from their point of view. If it's just going to be an additional expense. After all, they own the IP, and to pay for some talented individuals to come and work in-house on their premises and their headquarters, well, it probably makes much better financial sense. So then the question is, of course, well, what happens to the money given by, I can say given by Hillel, given by the Israel Innovation Authority? There's no ownership there. But on the other hand, the problem is, of course, that money is Israel taxpayers' money. And as long as the company is going to stay in Israel, then it makes sense. But as soon as that company decides to leave, the question is, how much sense does that make? So Hillel, please make some sense of that for us.
Thank you for the introduction. As Jeremy mentioned, the IAA is a significant player in the Israeli tech ecosystems. Many companies receive IAA funding, many technologies, and we support all different stages and all different types of technologies. So it's very important to understand where your company stands with that regard. Jeremy mentioned before the very interesting question: what is in it for Israel? And the Israeli policies, we see it as a tool for growing the Israeli economy through the technological edge. We see this as a tool for bringing employment, economic activity into Israel, further taxation, and what Jeremy just mentioned, we also see it as tools for keeping companies in Israel to a certain extent. And through taxation, we see that ownership of IP, especially in light of the OECD's BEPS regulations, is a very important. Ownership of IP is a very important measurement for taxation of the activity. So what I'd like to talk to you about is what you should be looking into when you're thinking of investing in a company or acquiring an Israeli company, and how this will affect what Didi mentioned before. And when you have this tailored solution for when you're acquiring your company, how does this figure into that? In other words, what you really need to understand are what are the obligations that you're taking on or that a company has when they receive the grants. And as mentioned beforehand, was money received? That's the first question you need to know if you're doing due diligence and before investing in a company. You really need to ask this question. We're involved with many companies, and this will be important in the future. If you do not intend on, if the company did not receive money, do not intend on taking grants in the future, then this may not be as relevant for you. But I feel it's still important, very important, as we are very prevalent in the Israeli ecosystem. So the grants that companies receive come with four main obligations. Their royalties, their obligations regarding manufacturing in Israel, their obligations regarding keeping with the IP and know-how in Israel, and their obligations regarding reporting investment in the company. Now, I'm going to give some short details about the first two, and I'll elaborate a bit more on the second two, as I think, and on their practical implications. So the money, the grants received are royalty-bearing grants. They may be referred to in other countries as conditional loans. The company is obligated to make royalty payments from revenue on the products and services which have the technology that was developed as part of the IAA grants. The standard royalty rate is 3%, and they're only up till the amount of the grants that have been received. This is in line with our policy that we want to participate in risk, and we don't. So if there's no success and no further sales, then no royalties are paid. So the question I guess you want to ask with regard to royalties is, well, what is the royalty definition the company is required to pay on? How much has been paid? What is the future open obligation that the company might have? And they may have already repaid all the royalties. They may have still outstanding debt or further obligations. Manufacturing, as I mentioned before, the goal of the IAA grants is to create Israeli economic activity, and part of that is manufacturing. Therefore, the default with companies that receive IAA grants is manufacturing in Israel. A company may apply to transfer the manufacturing abroad. This it needs the research of the IAA approval. This may affect your royalties, and the thing that you're going to want to look into is what the company has declared in its application. So the company should have a record of its applications. If it doesn't have them, it can request us to forward them to the company. And there's a section in the application which is called the manufacturing declaration, and this will highly affect the royalties or what your obligations are. Again, this may affect the royalties. It's important to know what the company's obligations are. The next two obligations are related. They're about investing in the company, acquiring the company, and what's going to happen. So I'm going to start with the later of the two, which is the investment reporting. When there's a change in the control of the company, or when a foreign investor becomes an interested party, acquires 5% of the stock, the company and the investors are required to report and inform the IAA of the change. And when there's a foreign investor, the investors are required to sign an undertaking, which the essence of this is that that you understand that the company has obligations to the IAA, mainly what we're talking about now, and specifically with regard to the transfer of IP and the transfer of manufacturing out of Israel. So if you're investing in a company, even if you're acquiring the entire company, this is something that you will need to do. This is not something that which entails any payment. It's just a reporting obligation. And now finally, the IP obligation. So the company, one of the policy tools that we have at the IA is that the company must own all the IP developed as a result of the grants. Now, two important points. One is this is the company and not the investor. The investor may own the stock in the company, but he does not own the IP. The company has to own the IP. Now, this is very important. I'm going to connect this to something that that Mike and Avram mentioned earlier. This will help you answer the question, who owns the IP? If the company has received IA grants, then the company owns the IP. We don't allow a situation where the IP is owned by someone else, which is developed through the IA grants. This is also with regard to the inventors, to advisors, other subcontractors. Mostly true with universities, although there are certain qualifications to that. In a case where the university is also a co-owner of some of the IP, there has to be a full exclusive license to the company to the related IP. So it's something that we believe is very helpful to investors to know that the IP is owned by the company. Now, the obligation, there's a restriction on transfer of IP out of Israel. So if you plan on transferring IP out of Israel, you need to receive the prior approval of the IAA, and this usually entails an exit fee. This is usually a one-time fee. That's why I'm going to put the most of the explanations into this. The exit fee for a transfer is usually sorry. I'm going to start with the limits. The minimum amount required to be repaid is the amount the grants received, and the maximum amount is 6 times the grants received. We find it very important for investors to know that there's a limit to how much the obligations are to the government with regard to the transfer. And there's a calculation, a function which lets you know how much you need to pay back. It's not something that it's not something we discuss. We don't have to argue about how much is being paid back. There's a simple calculation which takes into account the following parameters: the grants received, the company's R&D expenses, the purchase price of the IP, the amount of royalties paid, and the time passed since the grants were received. I can give an example, but the basic concept is that when you're taking the IP out of Israel and basically you're cutting off all the economic value, future economic value, the payment to back to the state of Israel is the ratio of how much we invested in the company with regards to the purchase price. So if we gave, I'm going to give it a simple number example. If we gave grants of $1 million and the company has invested an additional $9 million of its own, all in all, it's $10 million, and we're 10% of the total investment, then the payback to the country in the case of an exit will be 10% of the purchase price. So if the purchase price is $30 million, then you'll pay back $3 million. Now, I mentioned that there's a minimum and a maximum. As the maximum is 6 times the grants received, even if the purchase price is $100 million or even $1 billion, the maximum amount to pay back will not exceed $6 million. And on the other side of that, there's a minimum amount, which is you have to at least return the grants. So even if the purchase price would only be $3 million, an example we gave, and 10% of that would be $300,000, you'd still be paying back the full $1 million, which is, in my opinion, one of the if the question is how painful these grants can be, that's a situation where you're way under the minimum, then you have to up to fill the minimum. That's a painful situation. But other than that, in significant exits where there's that's usually not the situation. An important thing to note is that after an approval to transfer IP, no further obligations apply. There's you don't have to ask for the manufacturing. You don't have to pay any further royalties. So when you're acquiring an Israeli company that has received grants, you'll have to decide whether you intend to transfer the IP abroad or not. If the answer is no, and you do not intend, you want to leave the IP in Israel, then there's no fees required. Even if you have an SPA where you've purchased the entire company and you now own the company, and you may have been millions of dollars, there's no payment for that action. The trigger for repayment is the transfer of know-how. Maybe it's important to see what is the transfer of know-how and what are your options of collaborating with your, if you acquired a company and you intend to integrate this company within your global activities, what are your options? So one of the options would be allowing integration as you would with a client or with a competitor, like along the lines of a black box, or allowing integration to the software, but not giving IP rights. No further R&D would be allowed by the other companies. This would be similar to if you're a software company, giving an user license. all these things are not considered a transfer of IP. Another possibility is non-exclusive licenses. Instead of a one-time payment, there are back-to-back payments to the IAA. The pros of this is that there's no large payment, and if the license fails, then there's no further payment. Again, but the downside of this is that there's a very high cap. The cap is usually the full six times the grants received. There are other variations of transferring IP. There's transferring IP only for registration purposes without giving any economic or other legal rights, which requires approval but does not entail a payment. And similarly, if you're doing a transfer of IP, cross-licensing or cross-transfer, like you're taking IP out but putting other IP in, this may be done without further payment. What are the other implications of these rules for IP? This is, as Didi mentioned in the beginning, this is important for how you're going to be funding your company. Equity, debt, these are all acceptable, but you cannot fund the company through a cost plus a model, which would mean that the company would not own the future IP being developed by it. So that's something that you need to take into account. And regarding debt, as Didi also mentioned, that very often this is you'll use the IP as collateral or place a lien on the IP. This needs because there are obligations regarding the IP, you have to take into account that these obligations, even when you want to use the collateral and take it, you have to take into account that there are obligations. Also, I think those are the main issues. So this should give you a pretty good idea of what your obligations are, and when you're planning to invest or acquire an Israeli company, you should definitely take these into account, and you should be able to calculate if you'll need to repay, how much you need to repay. Of course, we're always available for further questions. If you can contact me or any other contact the IAA. We'd be very happy to help you figure out what you need to do.
Thank you very much, Hillel. At this point, if this is the end of the formal part of the seminar, and we're going to be discussing one or two questions now. Actually, I want one in particular. There were two questions that were posted, and one of them was asking about whether there's a regulation as to how long money stays, money given by the Innovation Authority, and so on. I think you pretty much covered that area quite thoroughly, and I would suggest that if anyone has any specific questions, that they contact you directly. Your email is on the contact sheet, which I minutes ago via chat. So I'm inviting everyone to contact you. I hope that's okay.
Look forward.
Another question, actually, posted by the same person, was in connection with a drug called Azilect. I understand it's something it has to do with treatment for Parkinson's. It was developed in the Technion, and that's pretty much all I know about it. And there was a question whether anything was done with regard to potential compensation. I presume the compensation not so much to the Technion, but to the developers, the inventors. Avram, do you want to say anything about this?
Yeah, sure. So as I mentioned in my presentation, Azilect was developed initially at the Technion in collaboration with Teva. So there is an agreement regarding between the Technion and Teva, and the inventor from the Technion was actually there's as part of this agreement, Technion was paid based on the development and the like. Now, what typically happens in universities in Israel is that the inventor, if he isn't in the university, he is entitled to part of the royalties that the university earns from that collaboration, from that license of his IP. And typically, the university employees' compensation is about between 30 and 50% of the amount of royalties received by the university from their collaborator. And I think that varies. I didn't see the actual question itself, but I hope I answered that question regarding royalties. So in this situation, and it's based on public knowledge, Professor Musa Yudim, who is the Technion inventor, did indeed receive royalties via the Technion because of his invention, based on these sales and the profit made by Teva for this Azilect, for the drug that he invented.
Okay, thank you, Avram. I trust that question was answered in a satisfactory way. It was one of the comments that, Rob, I'm coming back to you again. Right at the beginning, I guess we wondered together aloud how practice in Israel, practice maybe in the UK, how similar they may be or how different they may be. Apart from you, I see that we have a patent attorney from Germany here. We know we have Chinese representatives. There's someone from India, obviously the US. If anyone would like to chime in as to what they have learned in terms of how similar things or different things are in their home country, then now's certainly the time. So, and if you wish to speak, and feel free to weigh in.
I think generally speaking, Jeremy, the universities in the UK are a bit more, depending on the university. There are certain universities that are very active in startup and tech transfer, and there are others that really are not. They are more teaching universities. I think in Israel, it seems to me that most of your universities have that focus and are very successful at doing it. I think there is a tardiness in the UK with regard to a startup and when to do it. I don't think there is quite the drive that you have in Israel, Israeli universities compared to some of the UK universities. It's not generally true because there are some that do it extraordinarily well, but it's not a general picture. That would be my view.
Right. Okay. Thank you, Rob. Anyone else? Yes, Ariel.
Yeah. Hello from Argentina. In Argentina, the federal government devote a lot of resources to universities and to a federal center of investigation. But comparing with Israel, really the situation is that the activity between private companies and the governmental institution are very, very poor. It's a pity because the resources are wasted. There are a few projects that where the country obtain really economic results. I believe that a contribution of business minds could be very, very useful for our country. And really, I admire a lot the work that is done in Israel.
Thank you, Ariel. This is something that I do hear from time to time. I've actually been to various countries in the Far East where there's almost this unannounced competition as with regards to who is going to be more and more developed when it comes to tech transfer. Yes, I think that quite clearly when you have academic institutions where so much of the research is applied or can be applied to some of the many problems that 21st century Earth faces, clearly there needs to be a way to be able to get the technology or the developments out of the lab and into people's homes. Clearly, does take resources to do that, and it takes an infrastructure. There's a question that came up here that Didi, you might want to answer this, or Aaron. No, Aaron's not here. But Ami, you might want to take it. The question is, it's a totally different question. It was initially directed to Avram, but he's probably not the person to answer this. Is an employment contract that specifically states that no further compensation for service inventions valid?
The simple answer is yes. But as most things legal, it comes with yes, but generally it has been, I mean, in the past it was set aside, that decision, as a theoretical question in the first few cases that had to do with payment of royalties to employees, whether the waiver could be overreaching or overall, but the conclusion is that yes. I would typically recommend something more detailed, making reference that this includes a specific waiver of the rights under the patent law that Avram pointed out in his presentation, and not just saying, no, this covers everything. By the way, this is not only unique for the patent area, but also in other aspects of labor law. There are some rights employees can waive, there are some rights that cannot. But even though those that can waive, I would always recommend having a specific waiver and not just saying, and I waive anything else.
Okay, thank you, Didi. That actually reminds me that, and I think a number of years ago, hearing about the way service inventions are compensated by companies in different countries under different country law. As far as I recall, I think I had examples that both in Japan and Germany, that by law, there's certain compensation that has to be given to an employee as in lieu of his service invention, which is related to his contribution to the financial success of his employer. Which is obviously, if one wants to talk about differences between different countries, that clearly is a gulf.
Jeremy, if I may add, there was a ruling, I don't remember exact timing, but probably around 7 years ago, that said we don't need to deal in this specific case whether a general waiver is valid or not, because there was a specific waiver in this case. And that, side remark that we don't need a ruling about this created a lot of uncertainties in practice, which led a lot of companies to try and adopt policies, because what you suggested now is actually very complicated, because many times the invention is only commercialized many years after this employer has already left his employment. So how can you calculate his contribution or employment fees when he's not your employee for 3-4 years before the commercialization? How do you measure his contribution to the overall success if this is just one component? So companies rushed to adopt policies that had these mechanisms of fixed payment at various stages to try and address that uncertainty. But when it was later clarified that, yes, you can waive this specific right, then I think things went back to the way they were before and just include such a clause.
Okay, thank you, Didi. On that note, I think that we will draw the proceedings to a close. One of the things that we do in our firm, we've been doing since the beginning of this whole Corona period, where some people are working sometime in the office. Many of us work part in the office, part at home. Some people have been working only from home. We have daily meetings where it's not necessarily just to discuss professional matters, but other things which we wouldn't normally discuss during a day's work. One of those things actually was to do with one of Mike's clients who they obtained a breakthrough to do with FDA approval for a drug they're working on. And what Mike mentioned is that this actually shows us that in the field, whether it's the specific field of IP or fields around IP, which deals with development, it essentially deals with packaging those developments so as to be commercialized and giving individuals and companies the wherewithal and an incentive to commercialize. This is something which really, I think, gives a lot of relevance, a lot of meaning to what we all do. Everyone in this meeting has an interest, is invested in some way, in some part of this huge picture. We're all needed, whether you're the inventor, the investor, an arbitrator of rights, one who gives money, one who uses the money, it doesn't make any difference. Everyone is invested in so many things, especially, but not only, especially coming out of through tech transfer, but again, there are very many other channels as well, in trying to make the world we live in a better place. And I'm gonna just finish off with a thought that I had about getting back to Didi and the birds. I think, Didi, you mentioned that Israel is a major migration route. When both in the autumn and the spring, there's a huge migration. I think there are a couple of main corridors in the world where they fly. Obviously, in the autumn and the fall, southwards. In the spring, they're flying northwards again. One of those corridors is over Israel. And one of the things that you can do for whoever lives here or whoever, after we get past COVID, visits here, a wonderful thing to do during spring and autumn is to visit a lake in the north. It's not the Galilee Lake, it's not the Kinneret, it's just close by, called the Hula. It's in the Hula Valley. And they provide, because these birds are coming through, the powers that be there provide a tremendous amount of food on this lake for the birds. And it's an amazing thing to visit this lake and just to see the thousands and thousands and thousands of birds that make a temporary home there on their journey south or northwards. And in a way, I suppose you can really see there's a little bit of a parallel between that and between what we try and do here in Israel. No one is an island, no country is an island. There are ideas that come out of the universities and industry, and sometimes people just out of people's heads, just like that. In Israel, there's a special emphasis on advancing these ideas. Many of them, again, they're in the medical profession, in renewable energy, and you can think of many different fields where water technologies, where they start here, they get their initial nutrition here, but the ultimate destination is going to be worldwide. So I think there's a very nice parable there. And especially one thing about birds is that they feed on the ground, but when they need to really go somewhere, they spread their wings and they fly. And this is part of what the entire startup scene tries to do. Obviously one wants to more and more success, but as it is, there's a tremendous amount of success, and I think a tremendous amount of pride as well at seeing the very positive Israeli technologies that have reached all over the world. And right now, after this, we've had an enjoyable session together, 1.5 hours. So I hope this has given us all some food for thought. As I mentioned at the beginning, it is very good to see old friends. This is the only way that it's going to happen, but it's a great way to do it if we can't meet otherwise in person. It's good to see some new friends as well. And until the next time, I wish everyone a healthy and safe and warm winter. Thank you very much.